case briefs, and so much more. LSData's got what you're looking for.
In United States v. Fleet Factors Corp. Tri., a 1990 case heard by the 11th Circuit Court of Appeals, the United States sued 3 parties, including Fleet Factors Corporation, after hazardous waste was found at a textile facility. Fleet had obtained a security interest in the assets of Swainsboro Printworks, the textile facility, and upon foreclosure, hired someone to remove unsold equipment at the facility. EPA found toxic chemicals and asbestos, costing nearly $400,000 to remove. The court denied Fleet's motion for summary judgment, considering whether Fleet could be held liable for the damage under the Comprehensive Environmental Response Compensation and Liability Act, CERCLA. The court looked at whether Fleet's involvement in the facility could impose liability on Fleet. The court determined that the secured creditor exemption under CERCLA depends on the creditor's involvement, not their motive. Creditors could monitor debtors and make financial decisions without liability, but should investigate waste treatment and consider CERCLA liability. The case was returned to the lower court, with the court emphasizing Congress's intent to prevent irresponsible actions with hazardous waste.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.